Well, thank you, Briston, and it's a pleasure to be invited here to be able to speak to you. I thought about how to present this. When I went to UVA Law School, contracts was a full year course. And rather than giving you some incredibly watered down version of what I learned that first year in law school, I'm going to go about it a completely different way. I think that we learn best not by being lectured to about doctrine, but by hearing stories. And so, what I want to do is, I'm going to give you a little bit of a structural background for you to fit the stories into. But mostly, what I'm going to do is share stories with you of real life situations that you could find yourself in one day, and where I'm going to show you how those situations were handled, and hopefully, you're going to remember them many years from now. If you're working with a corporation or with an LLC, you get started by filing documents with the Secretary of State on sunbiz.org. Now, most people believe once they've done that, they're done. And of course, they have to file an SS4 for a taxpayer ID number. But they don't realize that's only the start, not the finish of the incorporation process. Many people, I might even say the majority of people who file an online corporation, let's say, will just file the articles and never do anything further. And that omission will go unnoticed for years because people don't know that there's much more that they have to do. For example, let's say you file your business and you bring your articles to the bank and they say, okay, that's what we need and we can open up an account for you. That's as far as people will delve into the subject. But let's say they want to go back to that bank for a loan. The bank is going to say, okay, we need to see your organizational documents. And you'll say, well, I showed you my articles. And they say, no, we're not talking about, we want to see all the other documents, the private documents that you're required to have, your bylaws. If you have directors, board directors, your initial director's resolution authorizing the issuance of shares to your shareholders. Where's the evidence that you own this company? You say, well, I filed the articles. That doesn't evidence ownership. Anybody can file articles. You have to have documents to evidence your ownership of the company. So I wanted to just bring your attention to this because so many people get this wrong. This isn't a contract negotiation point, but we're going through this logically. And at the very start, might as well get started correctly. So if you think just by filing articles that you've properly incorporated, you really need to talk to me or someone else who can help you with that. Now, if you're in business by yourself, you won't need this next document that I'm going to refer you to. If you, however, you are in business with other people, it doesn't matter whether it's a corporation or LLC, you have an operating agreement for an LLC, or you have a shareholders agreement for a corporation. Either way, it's a document that expresses the agreement of the parties who are the owners of the companies, how they're going to handle certain situations. Now, you're not legally required to have a shareholders agreement, unlike the other documents which I mentioned, which you are legally required to have, but just may not know about. So why should you have a shareholders agreement if you're not legally obligated to? Well, let's say you and a friend decide to go into business, and you've been talking for a while about this idea, and you finally decide to pull the trigger. And so you file the articles, and maybe you even got the rest of it right, but you don't have a shareholders agreement. Let's say down the road, either failure or success leads you to a point of division. And both can do that. I've seen people be very successful, and that can really create a problem. And one of the stories I'm going to tell you later on is about two guys who went into business. And many of the people I'm going to tell you stories about, incidentally, are in their 20s. So this isn't just old people law. This is for people who are young creatives who have ideas and want to do things, but just don't know how to do them the right way. So these two guys started a company, and they did organize it, but they didn't know about this type of agreement. And then there came to be a point where they were at odds with one another. And I'll tell you the story later, but the bottom line was they didn't have a document in place to cover that type of situation. Now, let me give you an analogy I think everybody can relate to. No people, when they're getting married, on the day of their marriage, are anticipating that they're going to get divorced. But statistically, there's a better than 50-50 chance that they will, unfortunately, in our society. And so in a business, no two people go into business thinking, oh, things are going to go wrong. We're going to disagree with one another, because everybody always starts out with the best of intentions. But then life happens and it doesn't always go the way you expect. And two people who are in complete agreement end up in a very different position. And one way in which you can provide for this is by a shareholders agreement. Suppose you couldn't work with this person anymore, yet you've built the business together. What would you do? You can't go to a court and say, rescue us. The court will refuse to do so in all but the most extreme circumstances. So basically, you're stuck if you haven't agreed to how this is going to be handled beforehand. And so in a shareholders agreement, you'll have what's called a buy-sell clause. You also might have a right of first refusal that talks about the duty to offer the shares to your partner before you sell them to a third party that your partner might not approve of. Now, another circumstance that I've seen this happen with a number of times is the death of one of the partners. Again, nobody ever expects that they're going to be the one to die early, but it does happen. And if you haven't provided for what's going to happen to the shares, you're going to end up with a situation where the surviving partner ends up in business with the spouse of the deceased partner, who may know nothing about the business and may have very different goals and understandings of the way things should work. And that quickly is going to dissolve into an untenable situation. So an ounce of prevention truly is worth a pound of cure. The time to resolve these questions of what's going to happen if we need to part ways is always at the beginning, when it's easy and everybody's more than willing to give a little to get a little, rather than where tempers are flaring, things have gone wrong, and now suddenly nobody wants to give an inch and the business isn't working. So that's the first thing that I'd advise you to consider if you're in business with other people, is making sure you have a shareholders agreement or an operating agreement if it's an LLC. Let's talk about the next stage. Once you get past just starting the business, hopefully you're going to have some customers. Now, regardless of whether you sell goods or services, if it's for any amount of money, chances are you probably should have a terms sheet that describes what your contractual relationship is with your customer. I've had chamber members ask me to prepare these for their businesses, and basically we'll think through the ways in which that business needs to be protected from all the things that can go wrong. If you don't have a term sheet, again, you're not required to by law, but the government is more than willing to supply terms if you don't create them, much in the same way that they will be more than happy to supply you with the rules of intestate succession if you fail to have a will. I don't ever remember anybody saying, oh, I'm so glad that my loved one died without a will. In the cases where I've seen it, the family is not happy because it is a much more unpleasant and difficult task than if they had just made clear what their intentions were beforehand. Again, an ounce of prevention really is worth a pound of cure. And this is an area where you can save yourself a lot of heartache if you define the nature of your business relationship with your customers. Now, with your suppliers, it's the same thing, but you might find it a little bit more difficult. With your suppliers, they probably will have term sheet that they expect you to agree to. And in many cases, these are non-negotiable, but in some cases they can be. Now, here's a general rule of thumb for you to keep in mind on the entire subject of contract negotiation. You will be told many times, oh, you just have to sign this, it's non-negotiable. People lie. And there's a very good reason for it. Let's say, and it doesn't matter whether it's a bank or it's a landlord or some other business, if they tell 10 people, oh, you just have to sign this, probably 7 of them are just going to comply, either because they don't know better or because they don't want to spend money to go to a lawyer. And so 7 out of 10 times, they're going to get their way completely because just uttering that sentence gets them the result that they want. Now, in the few cases where people say, well, wait a second, this is a business relationship. Shouldn't I have a say? Don't I get a voice in this? And if you have a reasonable amount of leverage in the business relationship, you should be able to negotiate almost anything. And that goes for bank documents that you've been told are non-negotiable. Can't tell you how many times I've heard banks say, oh yeah, these are our standard form documents. Even if I wanted to, I couldn't change them. And that's a half-truth. It is completely true that your loan officer probably doesn't have the unilateral authority to approve changes to your bank documents. That doesn't mean he can't get the approval from the legal department, which is the way it works. You negotiate with the loan officer. The loan officer goes through back channels to his legal. The legal says, okay, we could agree to this, we couldn't agree to that. Again, they're not going to tell you this because it's much easier for them if you just sign on the dotted line. And I'll give you some real-life illustrations later in stories. But this is just a true principle for you to be aware of for the rest of your business life. Just because somebody says something to you, don't take it as the gospel. If they have a reason to lie to you, there's a very good chance that they are. And even if it's not an outright lie, it's very possibly just going to be a misdirection or a lie of omission. So when you're negotiating, let's say, with a supplier, if you are a significant customer, chances are you probably can negotiate more favorable terms than what they have on their term sheet. I can tell you the term sheet is unilateral. It is designed to create an uneven playing field. I draft them. I know that's the way I prepare them for my client. That's my job when I'm preparing it for my client. The system is supposed to be adversarial. That's the nature of our justice system. You have a prosecutor and you have a defendant attorney. You've got a plaintiff and a defendant. You're both supposed to be represented by counsel. It's no different in a business relationship. Instead of it being hostile, it's cooperative. But that doesn't mean that there shouldn't be a process where you go back and forth and you reach an agreement, a meeting of the minds, as we would say in legal jargon, as to what the terms of the relationship are. Now, again, if you're in the position of buying or licensing Microsoft Word from Microsoft, don't waste your breath trying to get them to carve out special terms just for you. But let's say you are a significant customer of a particular vendor and you've never looked at their term sheet before. Get that term sheet out and take a look at it. And if you can't understand all what it says, show it to an attorney and have them say, well, what do you think of this? And they might say, okay, this is non-standard, this is non-standard, this is standard, but I think you could do better. And then make an informed judgment about what it is you're going to agree to and not simply out of ignorance sign papers because somebody put them in front of you. So those are common relationships that any business is going to have, business with your customers, business with your suppliers. But what I want to focus most of our time on are those relationships where contractual negotiations are going to have the biggest impact on your life. And I'm talking about those high-value transactions that most businesses will enter into at one point or another. Now, the most common of these is probably the lease agreement. Now, back when I started my career back in 1987, if you were in business, it pretty much meant that you would be leasing space somewhere in a commercial building. And regardless of whether it was a service that you performed, like you're a lawyer or you had a product to sell, if you wanted to be in business, you had to have a business space. And back in 2001, I made the decision to move into my home, and it's one of the happiest decisions that I made in my life for financial and personal reasons. And many of you may have discovered for yourselves after the pandemic that due to advances in technology, it is possible to do from your home many things that would have been impossible just a generation ago. Nonetheless, there are still many businesses where having a lease really is not an option. You just have to have a business space. So what I want to do is really talk to you now about all the different things that go into making good decisions when you're entering into a lease agreement. I guess I'll start by saying the different categories of things that are to be negotiated. The first is obvious, at least on the surface, and that is price. If you're going to shop for space, you're going to ask around, what's the first question you're going to ask? How much is the price per square foot, or what would the rent be per month? And that's certainly one expression of the price term, but it's not the full expression. And you should be aware that when you're inquiring to make an apples and apples comparison, you're looking at not just the base rent, but you're also looking at the common area maintenance or CAM charges, and you're also looking at what other charges may be associated with taking on that lease. Finally, you're looking at the escalation clause. Any well-drafted commercial lease is going to have an escalation clause that provides how the rent is to be increased each year that you're there. There are many ways of doing that. You need to understand how yours works and whether or not you could negotiate a better one. So once you've got that price term, then the next question is going to be negotiating the business terms. Now, this is usually done through a document known as a letter of intent or an LOI. It doesn't always have to be, but most of the time I would say that it is. Within a letter of intent, it is usually a one-page document. I've seen them 2 or even occasionally 3 pages, but usually it's 1 or 1.5 pages. And it contains the expression of the parties' agreement on material business terms. Now, what do I mean by that? Start date, termination date, what the term of the lease is going to be, whether or not there are any options to renew, whether or not there are any rental concessions, whether or not there are a bunch of different things that could be negotiated by parties up front. And they're usually referred to as business terms. Once this has been done and the parties have a meeting of the mind, they will express that meeting of the mind through this signed letter of intent. Now, this is a mistake that many people make, even experienced business people. They misunderstand what a letter of intent is. At the end of every letter of intent that I've ever seen is a paragraph that says that this is a non-binding agreement. A contract is a binding agreement as to a specified subject between one or more parties. A letter of intent is not. It is non-binding. People see those magic words and they think, oh, okay, I don't have to take this seriously because I don't have to abide by this. Nobody could make me follow through with this if I don't want to. And they would be absolutely right in saying that, and they would have missed the biggest point. It is true that a non-binding letter of intent does not force you to go through with the deal. You can back out at any time without recourse. However, what people don't realize is that you have now negotiated away everything that you could have negotiated for during the letter of intent stage. So I'll give you a real-life example of this. I had a client of mine purchase some land and then decide he was not going to build. And so we wanted to sell the land. And he hired a broker, which is the correct thing to do, and listed the property, correct, entertained offers from the various parties to basically see if they were interested, and also correct. And then they started talking about the letter of intent, also correct. Now comes the mistake. He signs the letter of intent. Next day, contacts me, his attorney, and says, hey, Harris, got great news. I've got, someone who's interested in buying the property. I said, terrific. Where are you in the negotiations? Oh, we just signed the letter of intent. I said, oh, okay, send it over to me. And I saw the letter of intent, and I immediately called him back. I said, okay, this isn't good. This deal isn't structured correctly. And so I said, this should have been negotiated differently. Let me see if there's anything that I could do. And so even though it was just one day later, I tried to basically reopen some of the business terms. They just said, not a chance. You don't have to do the deal, but if we're going to do the deal, we're not going to let you go back on what you've agreed to in writing. So even though a letter of intent is non-binding, effectively it is the final expression of the terms that you've agreed to. So the time to really think this through is not after you've signed it and right before you sign the lease. It's before you sign the letter of intent, so that if there's anything that's missing or anything that needs to be changed or restructured, you can do it, and then the other side will have given their stamp of approval, and they can't go back and renegotiate a change. When I say they can't, well, they could back out of the deal, but effectively, I've just never seen it done. People back out of deals, but they never change non-binding terms that they've already agreed to in principle. So there's a third stage to the lease negotiation, and this is the actual lease agreement itself. Here is where the parties go from a one-page letter of intent to a 12 or 20-page, probably small font, single-spaced legal document. What's the difference? The difference are all the other terms, not the business terms that the parties are thinking of, but the legal terms that the lawyers think about. Now, if I were to ask a room full of business owners, and I'd say, what's the most important thing to you when you're looking to lease a property? Is it A, price, B, legal business terms or legal terms? I imagine almost every one of them would say price. And certainly price is very important, but I'm going to make what I think should be a shocking statement to you. I think price is the least important of the three. Let me explain why. Ultimately, everything does come down in the business world to economics. But price does not represent the entire equation. It's one term in an equation. And the rest of the terms in the equation oftentimes matter much more than you think they do. And I'm going to give you numerous illustrations of this so that hopefully at the end of our hour together, you're going to say, I didn't realize how important all that other stuff was. And let me give you some specifics. Right now, I'm helping a young man, again, in his 20s. He's just about to acquire his first business. And this is his first lease negotiation. And fortunately, he's taking over from a client of mine who was kind enough to recommend me as his attorney. And so now I'm helping this young man negotiate with the same lessor that I've negotiated with before. He's never done this. And so after our first meeting together, he said, wow. He said, this reminds me of what I've been doing during the day. He said, I'm in a program where I basically, I'm being trained to do this kind of business. He said, I feel like I'm in training. It's like I'm learning the legal stuff they didn't teach me in this program, which only taught me my business. He said, I said, that's exactly what I'm doing with you. I'm training you so that you're not only getting the benefit for this one time, but hopefully for the rest of your life. So in the process of the negotiations, I instructed my client, go out and find comparable space and see what the market rate is for your kind of space in that area. And he did, and he found the range of it. I said, okay, now that you're armed with that information, you want to go in and negotiate the price term alone. The landlord won't want to do that. The landlord will want to negotiate everything. Don't let him. Because the landlord knows that he'll have to give up more if you do it in stages. So only deal with price to start. And so I said, the landlord is asking for this. See if you can get that. And basically it ended up with, he only was able to get $1 a square foot reduction. There are a couple reasons for this. The landlord this time had the bargaining power. My client had a strong desire to take that particular space. The landlord knew it. The landlord is also a probably 9 or 10 figure entity. And so they have all the monetary power. But yeah, I've dealt with this same landlord before. And the last time I was able to get much bigger concessions because in that particular situation, my client had the leverage and I was able to leverage that into a much better deal for him. Here, my client could only get a little bit of a concession on price. And the reality is when you're negotiating price, usually you can't get a big concession. Let's say it's a $35 per square foot rate that the landlord is requesting. You can't go in there and ask him for $25 and seriously expect that you're going to get that or even something in the middle. You might be able to get $1 or $2 off of the per square foot price, but realistically, that's about all that you're going to be able to get. Now, over the course of your lease, that $1 square foot concession could amount to thousands of dollars. So was it worth the time to do your homework and have examples of why you thought you should get a better rate and get them to come down $1 a square foot or $2 if you can get it? Absolutely, it's worth your time to do. But that benefit will probably be measured in thousands of dollars. Now, let me give you a real life example. Another gentleman, again, this is someone who, when I met him, was in his 20s, is now in his 30s. And he's been successful in his automotive repair business, and he's opening up a second location. And so we needed my assistance with with doing the lease. And I had done the lease at his last space. And so he trusted me. And he said, Harris, you tell me what to do. So I walked him through how to negotiate it. And it was a long negotiation. It went back and forth for weeks. And toward the end, they were down to one point they disagreed on. My client said, I'd just like to give him this one. And I said, don't do it. I said, this is too important. I said, you've been reasonable on the rest. Stand your ground. So my client did, and the landlord eventually consented to it. And so 6 months later, I opened up an email from my client. It was a thank you note. He said, I just wanted you to know that that clause that you insisted that I fight for, he said, it just saved me $60,000. Because under the way the lease was drafted originally, the tenant would have been responsible for all repairs to the building. Now, that's not the industry standard. And that's one of the reasons that I insisted my client hold firm on it. I said the industry standard is that the landlord is responsible for the structural members of the building. And so for him to have you be responsible for that as well as the other things, I said that's not standard and you should fight for that. And so again, because of our relationship, it made him a little uncomfortable, but he stood up for it. And 6 months later, it was a difference of $60,000. So that's 10 times the amount of benefit he might have gotten from that $1 price difference that someone else might have thought, oh, that's really the important issue. The business terms in many situations and the legal terms can, by orders of magnitude, be more important than whatever small amount you can get as the difference in price. People don't understand the legal terms. And if you've ever gotten a lease and tried to read it for yourself, you know, 1, it's long, 2, it's boring, and 3, it's filled with a lot of things you're probably not sure exactly what they mean. And so most people, whether it's because they don't want to pay an attorney or because of all the things I just mentioned, they just go on, or maybe the landlord says to them, oh, it's non-negotiable. Usually, there are a great many items to be negotiated in the lease because the lease has been drafted by the lessor's attorney. What's his job? His job is to draft as one-sided a contract as he can for his client. By definition, it's not a fair contract. If you're agreeing to it, then you're agreeing to something that sight unseen, I can tell you, is unfair to you. And it's not because that's mean. That's just the way the system works. You're expected to be able to have your own representative call them on all the things. And I'll tell you a funny story here. Now, this wasn't with the lease. This was with a bank document. Years ago, when I started out my career at McGuire & Dvores, I highlighted a clause and I brought it into my partner. And he read it and he got mad, one of the maddest I've ever seen him. And he called the banker who was downstairs, lower in the building, up to the 12th floor. He said, I want you to explain this to me. And highlighted are the words, and I'm not making this up. The bank can do whatever it wants. Literally, that was in the loan document. The bank can do whatever it wants. And I'll tell you exactly how it got there. Some associate was drafting the bank documents just like I did when I was at a big firm. And he thought it would be a funny idea, just a prank, to put something completely outrageous into the bank documents just to see if anyone would ever catch it. And so my partner demanded an explanation from the banker as what type of outfit are you running that you'd put something in there so you could take me and throw me out this 12-story window and that would be okay? And the banker got all flustered. He's like, well, he said, I've never seen this before. I didn't know it was in there. And my partner said, well, how could you not know it's in there? It's your document. He said, nobody's ever noticed it before. And that was the truth. No one had ever taken the time to actually read what was in the document to discover that there was a joke actually in the document that people had been signing year after year after year, and nobody actually caught it. Now, you might think, well, Harris, there's a reason that people don't go through that. Yes, it costs money. Yes, they're boring. But I can tell you how important an impact this can have on you. And I've kept all my stories, and probably all my rest of my stories I'm going to keep anonymous. This one I'm not going to keep anonymous because you know the party involved, and I've heard them tell other people's stories about this. So attorney confidentiality has been waived by my client. I do the lease work for Christian Help. And I enjoy working with Vicki Martin because she is a very sharp lady. And we've had some very interesting conversations through the years about leases. And I remember time that she sent a lease to me, and it was on the long side. And so I reviewed it. And so I said, let's make an appointment to talk about it. So she called me up, and I looked at my watch when we finished. It was 2 hours later. It took me 2 hours just to explain to her all the things that were in the lease that I felt the need to point out to her because I didn't think she would understand on her own. 2 full hours. As I bring up that it's Vicki Martin because I want you to understand, this is not somebody who's inexperienced. This is somebody who's very sharp, very savvy. It took me 2 hours speaking on that level to communicate all the relevant information. And she took notes on everything, and she went back to the landlord and very heavily negotiated that lease because there were a lot of things in there that were unfair. And when I say unfair, let me explain what I mean. In every industry, there are norms, there are standards. People who are in the industry know what they are. People who are not in the industry don't. Being in the business of negotiating leases, I know what normal is. If you've never negotiated a lease before, it's impossible for you to know normal. Now, let me give you a really important illustration of the same principle. How many of you have gotten advice from people you know about a lease, about a legal matter? I've seen this happen again and again and again. Give you an example in another context. Client came to me and said, I'd like you to set up this trust for me. And I said, well, I'd be happy to. Explain to me why you want a trust. We had a conversation. By the end of by the time he finished talking, I said, okay, I can do this for you if you instruct me to, but I'd rather not because you don't need it. It would be a mistake for you to set up this trust. The reason he was doing it is because his good friend had a trust set up for him, and his friend said, oh, you got one. They're really good. And so he took his friend at his word. Because his friend got a trust, he thought he had to get a trust. Well, I don't know what the friend's circumstances are, but every circumstance is different. So it is with leases and with businesses. When people give you well-meaning advice, they're usually speaking from a sample size of one. Maybe they've had one business, and they've had one situation like this, and based on how that went, they're saying, oh, never do this, or oh, you should always do that. And they're dealing from a sample size of one. It makes no sense at all for you to listen to them, and you're not being disrespectful of them. Doesn't mean that you're not trusting them. They're just simply not qualified to speak to you as an expert in a subject where they have one experience. You want someone who understands the full range of what goes into lease negotiation to opine on whether or not a particular lease needs to be negotiated. Now, I'll harken back to the earlier illustration I was giving you, this young man who's now taking over his first business. And what I've done is basically explain to him, okay, these are the different kinds of terms that you should be considering. Now, let's prioritize them for you. When I negotiated the exact same lease for his predecessor, it was a completely different process because even though it's the exact same physical space, exact same landlord, my client's different. One was at the end of his career, the other is at the start. And so I'm thinking about this transaction in a completely different context. And so what we did was we established what his priorities were. And anytime you're going through negotiation on something complex, you're always going to have to make a list of 3 categories. And this is important. So if you're taking notes, write this down. Category number 1, these are deal breakers. If the answer to this is no, I'm walking. That's simple. Then there's category number 2. These are the things I really want. Again, not necessarily deal breaker, but I'd really like these. Category 3, these are the things I'd like to have. And what you do is you've got to create a list, because if you spend time with the list, you're going to start moving things from category to category. And you said, well, at first I thought this was really important, but now that I've had a while to reflect on it, I see how everything fits together. I'm going to move it from absolutely must have to I'd like it, but really there are other things I want more. And until you've actually made the list, you really can't prioritize it. You're just doing so inefficiently. And so I helped this young man to create a priorities list. What mattered most to him? What did he have to have? What did he really want? And what would be nice to have? Then we talked about the different stages of the negotiation, and we gamed it out together. Briston mentioned at the beginning, I like to play games. And there's some game playing that goes into negotiations. You need to understand how the game is played, because you can think of it as a dance, you can think of it as a strategy game, but there's a very real order in which things are done. And if you understand that order, you can make it work to your benefit, or at least not have it work to your detriment. And so I brainstormed with my client. I said, let's talk about how we're going to go through this. Don't tell him about me to start. I want you to do the first part of the negotiations yourself, because this landlord has dealt with me before. If he finds out I'm involved, he's going to become much more defensive. I'll tell you what to do, how to approach it. And at the end of that meeting, I said, okay, now tell me how you're going to approach this conversation. And so we role played it. And he said what he was going to say. I said, that was really good, but here's this one thing you should change because of this. He went, oh, I never thought about that before. And so I kind of coached him through to where he could do that part of the negotiations on his own. Now, once we get further in, we're now 2/3 of the way through. We're all the way up to the letter of intent. Once we get past the letter of intent, then my client's going to disclose that he's hired me. And then I'll take over for the heavy lifting of negotiating the legal terms. And because that's going to be too complicated for him to do. But things like price and the other issues, he could be coached through how to negotiate them. Let me liken your hiring an attorney in this type of situation to your buying insurance. Now, most of you probably have homes. Your mortgage company may require that you have property damage insurance. If you didn't have a mortgage, would you still do it? 99% of people, at least until recently, rates have gotten crazy enough that things are changing. But until recently, for virtually everyone, the answer is yes. Of course I'm going to have property damage insurance because I'm trying to protect myself against the very real possibility that something catastrophic could happen, and it would be irresponsible for me not to guard against that. That's what I do for clients with leases. Now, you might be thinking, well, Harris, there's a big difference between my house and just the lease in my space. I'm only paying $3,000 a month rent. How can you compare $3,000 against $300,000 for my house? But what I'd say is, okay, let's count the cost. If it's a 5-year lease and you have a $3,000 base rent, add to that the CAM charges, which are above it. Add to that the escalation clause increases that you'll have each year. And that $3,000 a month lease represents a liability almost as much as you have in your house. Actually, much more than what you have in your house, because the bank mostly owns the house. It's going to be in the hundreds of thousands of dollars, your liability on this lease. Why would you want to close your eyes and sign on the dotted line and not know what's in there, especially if I'm telling you that there are industry norms that you should be able to get if only you know to ask for them? Sadly, most people don't, and they just sign on the dotted line. Now, in most cases when you're dealing with a landlord, they're going to require you to use their lease. And their lease, as I've explained, is completely one-sided. And that's why you need an attorney to level the playing field to where there's something for them and something for you, but at least there's a balance. Maybe it's, instead of being 5 for them and 1 for you, maybe it's 4-2, maybe it's even 3-3 if I've been able to really have a successful negotiation. But there are times when you may have the opportunity to draft the lease yourself. Thinking of a client years ago, it's actually a client I've already mentioned, but in another store, had me review a lease that was drafted by an unsophisticated landlord. It was a short lease, and I would have said this lease is completely inadequate for the space. However, my advice to the client was not have me redo the lease. I said, in many areas, this lease is more favorable to you than it would be if I drafted for you because of what he has omitted. And this is a really important concept. Let's say you reviewed something and you read every word and you used books and you went and watched videos and you looked up every single clause in that entire lease and you said, Harris, I'm prepared to discuss every word in this contract. I've devoted 420 hours. I know this lease. What I would say is, well, that's very nice. What about all the things that aren't in there that should be? And you'd have to say, oh, I only reviewed what was on the page, not what wasn't there. Many times, that's the important part of what I do, is not merely revising what's there that's wrong, but adding what's been omitted, because guess what? What's been omitted is usually the part that would benefit my client. So let me transition now to another situation that you may find yourself involved in, and that is if you're going through the purchase or the sale of a business. If you're buying someone's business, it's with the hope that you're going to be able to make a good living running that business. One day, hopefully, you've built a business to the point where you're able to sell it and make a nice profit and hopefully retire on what you've made from it. Anytime you're dealing with the purchase or sale of a business, there are going to be stages, and they're very similar to the stages that you had with the landlord. The initial stage is going to be just the verbal communication. Do we have a potential match? Then there'll be a letter of intent. The letter of intent may be significantly longer. I've seen letters of intent be 5 pages long when they're talking about the sale of a significant business. Then we get to the actual document, which is actually not one document, but many. The big document, the master document, is usually called the asset purchase agreement. But there are many ancillary documents that involve financing, that involve covenants, that involve guarantees, that involve other restrictions, involve all different types of related issues. There may be a lease that's being folded into the deal or a building. So it's a highly complex subject. This is absolutely not something that you want to do on your own because it's far more complex than just a lease. If you're buying the business, you need to be prepared to do the due diligence to make sure you know what you're getting. Normally, my transactions are one-offs. I get hired to sell a business, we sell it, the transaction over, I'm done. Here, this was an unusual situation because my client was in a particular industry, and a big national player was coming in, buying up lots of small businesses in that industry. And so they had a big national law firm that drafted all their documents. And so they're dealing with these local, $1 million or $2 million businesses that don't have sophisticated representation. And so most of them would just go along with whatever the big national company said would be done. Well, my client had gotten burned before. He bought a business before he knew me. And afterwards, he came to me and he wanted to do something. And I said, let me look at your paperwork. And I called him and his wife in. And for an hour and a half, I went through and showed them all the things that they had agreed to that he had no idea about. And he shook his head. He said, I'm never doing anything again without having somebody tell me what's involved. And so he was someone who was going to make sure it was done right. And so we dealt with this big national firm, and they want to use the same documents they'd used with all these other companies. Well, I came back and I had a lot of changes. And what followed was a very hard month-long negotiation. And at one point, the vice president of the company was dealing with my client, said to me, he said, I'm telling you that this is the way we always do it. He said, why are you listening to that attorney? And so my client said, how old are you? The guy said, well, I'm 35. He probably got Harvard MBA or something. I'm 35. He's vice president of this national company. And so my client said, well, my attorney's been doing this longer than you've been alive. And that was the end of the discussion. So eventually we got the deal done. And it ended up getting done 1 o'clock in the morning on a Sunday. And it was a very intense negotiation. And the gentleman on the other side was a gentleman. And I respected him, and we had a good working relationship. And afterwards, he said, it was a pleasure working with you. But I have to tell you, he said, you really pushed hard. And in other words, like you pushed too hard. And I just said, that's my job. My job is to get the best deal that I can for my client. And so 6 months later, the big company, the one that had been buying all these businesses, went through a national restructuring where they refinanced everything. And they went back to all the little business owners that they had bought from, who they're paying out over a period of years. They're saying, oh, you need to sign all new papers with us because the new bank is requiring you're going to have to restructure your deal. And so my client sent me the paperwork and I reviewed it. And he said, do I have to agree to this? I said, no. So we went to the president of the company. He said, I'm not signing this. The president said, you have to. We're all signing. He said, I'm signing. We all have to sign it. And so he had me writing a memo on the subject. The president read the memo, checked it out, told my client, you don't have to sign. There was a subordination agreement that I had negotiated some clauses in that nobody else touched. Everyone else in the organization had to restructure their deal. My client didn't. And so that was a very affirming negotiation because, like I said, normally it's a one and done. Here my work was being compared with all the other people who were similarly situated. Only my client got to avoid having to have his deal renegotiated after the fact. This is a young man who started a tech company, and it's done well. And he started with a partner. And when it was in planning stages, they got along perfectly. They had these wonderful dreams of the future, what it would be. But then they started the business, and they started having to grind out, the product, and just get content out there. And it's a lot of hard work. And my client found that he was the one doing the lion's share and the other guy wasn't pulling his weight. And they'd had many disagreements about this. And it got to the point where he just said, I can't be in business with him anymore because he's freeloading. I'm doing the work and he's taking his percentage of the profits based on ownership, but he's not holding up his end of the bargain. And unfortunately, there was no shareholders agreement. And so I had to tell my client, there's no way I can force him to sell. And so he said, well, what can you do for me? And so I said, I have to invent something. And so I came up with something custom for that particular situation where I did research on nationally available statistics and put together this whole statistical analysis to come up with an approach for valuing this person's share of the business. And then afterwards, I prayed because this truly was something I'd never seen anyone do before. And I just prayed that this person who had said no to everything up to this point would be receptive to it. And 24 hours after I prayed, he called up my client and said, okay, I'm willing to do the deal on the terms that you outlined. So that was very expensive. It would have probably cost 1/10 or 1/20 that cost to get it right at the outset. But that's really one of the lessons that I hope I'm able to impart into you, is that to get things done right when it's the beginning costs a tiny fraction of what it costs to correct the problem later on. Getting things done through a lawyer is like buying insurance on your most valuable asset, which is your business. That's how you make your living. If something bad happens to your business, everything is going to suffer. And that's my job, is to help you to figure out how to put together something that's going to be the best that it can be for you. There's another context. I've talked about selling your business because you're retiring. I've talked about selling your business because you can't get along with your partner. There's another context that I often see, and that is where it's the passing of the torch from one generation to another. Now, it may be your parents' generation that you're going to inherit a business from, or it may be you looking to leave a legacy for your kids. But this is something that successful businesses often will have to deal with. How do you pass the torch from the older generation to the new one? And I was contacted by a woman whose husband was about to die, and he literally was on his deathbed. And so the first thing I had to do was get a will in front of him because he literally was dying. And so I rushed there the next day, got the will signed, and within a very short period of time, he had passed away. There was no time to do really any planning beyond that. Afterwards, the widow came to me and she said, I work in this business, but I don't have the mind for it that my husband does. He was really the head of the business. Both my sons are in the business, but they don't get along. And so I want to hire you, not just to transfer the business from me to them, because now I own all of it. I want you to structure this transfer in a way that's going to bring my family back together. And this was one of the most challenging assignments that I've ever had, because there was a long history of issues in the family, and some of them were work-related. And over a period of 2 years, I negotiated this sequence of transactions that would be between the mother and her sons. But I did it in such a way as to try to maximize the likelihood that I could take people who are antagonistic to one another and get them to be able to work together cooperatively. And as I mentioned, this was it was an expensive process. I didn't do it alone. I was working with a financial planner, and I was also working with the CPA. This was a complex series of transactions. And during the process, it actually got very heated. And one of the sons, and I should mention, everyone involved, the professionals on my side and the boys on the other side, all born-again Christians. So I like when that's the case. It's not always the case, but I do enjoy working for Christians. Nonetheless, it doesn't mean that Christians don't have emotions. And one of the brothers didn't have things go the way he wanted them in a particular phase of it. And he got mad and he yelled at us. And he really chewed us out. And ultimately, we stuck to our guns and we did it the way that we said we were going to do it. The mother said, it's my company. I make the rules. One day it'll be yours, but for now, I'm doing it the way my professional team has instructed me to. Years later, the financial planner is at a CEO meeting with heads of companies. And it's like a marketing or support groups for CEOs. And the financial planner is there at the meeting, and he sees the brother who yelled at us. He's like, oh boy, I hope this isn't going to go badly, because he's there to get business. And wouldn't you know, it was that brother's turn to speak at the CEO meeting, to tell the other CEOs a story. And the story he told was of how he ended up, acquiring the business. And so he told the story of what we did. And to his credit, he was honest. He said, at the time, I was mad. He said, they didn't do things the way I wanted it done. And, I let them know. He said, but a couple of years have gone by. And my brother and I are working together in a way that I never would have thought possible. Not only are we both still with the business, but we've actually gotten a lot closer. The company's doing well. He said, if I had to do this again, that'd be the team that I'd hire. Because, I pushed back as hard as I could and they stood their ground. It turned out that was the way to bring us together as a family. Because it's not always about the money. And in this particular case, it was made very clear to me that the money was the secondary objective. The primary goal was to take a dysfunctional family and to create an environment in which they could come together and be a team. It's, I guess, probably my favorite part of being in the business is when you can really make a difference in someone's life. Because anybody can, negotiate the monetary amount on a lease. But when it comes to making sure that your client is protected or coming up with a creative way to structure a deal, that's something that really is an art. And it's probably the thing that I enjoy the most about practicing contract law.